Welcome everyone to Nelligan Law's Return to Work webinar. Thank you for joining us today. My name is Karine Dion and I'm an employment lawyer at Nelligan Law. I represent both employees and employers in both official languages.
And my name is Malini Vijaykumar. I am also an employment lawyer at Nelligan Law, and my practice tends to be more on the employee side of the equation.
I think we can all agree that not only is the impact of COVID-19 on the workplace widespread, but the impact of the pandemic is uncharted territory for everyone. It's leaving many employees and employers with questions about how to navigate work closures and now in the new phase to return to work. So in addition to our regular employment practice at Nelligan Law that provides legal assistance to those who need it, for the past 3 months, Nelligan Law has also been offering a free employment helpline to help guide people through some of the questions that we're going to go over today. We've received so many calls through this helpline that we thought it would be a benefit to the community to do this webinar to address some of the most frequent questions that we've been hearing. In case you do have any additional questions after today, please note that the number for our helpline is 613-231-8275, and it can also be found on our website at nelliganlaw.ca. That said, we're happy to discuss some of the most frequent questions coming in from employers and employees here today.
So as Karine mentioned, there are definitely some questions that have been very top of mind for both employees and employers concerning the return to work. We're going to look at three main categories of these questions. The first one, definitely self-explanatory: workplace health and safety. Employees are wondering how to go back to work safely, and employers are wondering what they can do to make their workplaces safe. We're also going to look at the topic of parental leave and childcare. So for employees who are new parents or who are anticipating becoming new parents, how might their entitlements and rights be affected by the pandemic and the return to work? And we're also going to look at changing roles and responsibilities. So, if you've been on layoff and you're coming back to work, but your employer wants you to come back on different terms, or if you as an employer have had to institute a pay cut and you're wondering what potential legal issues might be involved with that, we're going to be discussing that as well. And then towards the end of the presentation, we're also going to mention some of the questions that we see popping up on the horizon in the coming months and sort of future issues that we might face in the workplace.
Sorry here guys, I'm trying to learn for the first time how to share my screen. Okay, so the first topic we're going to discuss today is workplace health and safety and the right to refuse unsafe work. One of the questions we've been hearing a lot on our helpline is, what are employer obligations to provide a safe and healthy workplace as it relates to COVID-19? So now that we're in phase 2 of reopening, obviously many workplaces have opened, will continue to do so with increased staff and increased hours of work. Under Ontario's Occupational Health and Safety Act, employers do have an obligation to take every precaution reasonable in the circumstances for the protection of a worker. And this includes preventing the spread of an infectious disease such as COVID-19. Although what's deemed to be a reasonable precaution is not directly defined in the legislation, COVID-19 may very well have expanded what this term would otherwise include. So this employer obligation obviously has to be balanced with employee rights, and the most important one in this case would be privacy rights. So obviously, every workplace is very different. What is reasonable for one may not be reasonable for another, and the standard for employers is not perfection. Employers are encouraged to establish return to work policies that aim to reduce the spread of COVID-19 in the workplace and to make sure that these are properly communicated to and understood by their employees. They can either be posted around the workplace or handed out individually to each employee. So the government has also set out some risk mitigation strategies for workplaces. based on the different workplace factors in order to help draft these policies. Some of these factors include proper communication about the risk and how to mitigate it to their employees, posting signs, encouraging frequent and proper hand hygiene, such as washing your hands for 20 seconds with soap and water, or using a sanitizer that should be placed around the office, physical distancing rules. We all know to avoid handshaking right now, keep a distance of 2 meters or 6 feet from a person next to you, avoid touching one's face, proper respiratory etiquette, such as coughing into an elbow, posting signs asking ill clients or customers or even workers to stay away from the workplace, canceling or postponing non-essential meetings or travel. If you can't avoid physical distancing at your office, then employees should consider having employees work from home or continue working from home if they haven't been doing it, or if they have been doing it, and also possibly wearing a non-medical mask or face covering. So obviously, recently a lot of workplaces have been moving towards communal office sharing. This will now be a problem. We do need to avoid sharing communal office equipment and supplies, and also office space to maintain that physical distancing. One way to do that is to reduce the number of workers, customers, clients that are in one given space at any given time, and also modifying infrastructure. I'm sure you've seen a lot of plastic divides. I know in my building I have a concierge, and there's a plastic divide now between them and the people living in the building. So all ideas of how you can maintain a safe workplace. And some other examples I've seen recently, I actually went shopping the other week, and when I walked in, I was asked to sanitize my hands. On the floor, there were arrows on how I was allowed to walk around the store. And there were also stickers about how much space that should be kept between two different customers. If I wanted to try on clothes, I had a maximum of 5 items I could try on for the day, not just at any given time, but after those 5 items were up, I had to go. At other locations, they do take temperature checks of customers before they come in. So these are just some examples of what employers can do at their workplace to help protect not only their workers, but also the people entering their workplace. Of course, here at Nelligan Law, we would be happy to help employers draft their policies on what would be appropriate for them, because as stated, every workplace is very different, so the needs will be very different per workplace. Something employers should also consider doing is asking workers who have tested positive for COVID-19 or who have been in contact with someone who has tested positive and might be showing symptoms to self-isolate for 14 days until the symptoms have resolved. They no longer have a fever and they're ready to return to work. So the employer does have an obligation to keep its workplace safe. And because of that, it can require its employees to report COVID-like symptoms and positive test results for COVID-19 to their supervisor, to their manager, or whoever else is in charge. This continues to be the case even when you're working remotely and you're coming into the office maybe just once a week to pick something up. You should still advise your supervisor or manager if you're an employee if you've tested positive. And if that supervisor or manager is advised, they might need to tell the office or other employees that were in close contact with this infected individual that they too need to go home and self-isolate as they've been in contact with someone who has tested positive. Now, the employer should generally avoid disclosing a specific employee's personal information, such as who tested positive. They should only really be disclosing what's necessary because you want to avoid being offside privacy laws as an employer. Now, sometimes workers will refuse to self-isolate. At that point, the employer might be forced to refuse them physical entry into the workplace, revoke any pass, like a swipe pass that might allow them entry into the workplace in order to protect the workplace and the other workers. Now, a lot of people have a tendency to want to continue working even if they're sick or unwell, either because just their workload, they're just a hard worker, or possibly out of fear of reprisal from their employer. But this is not the time to do that. If someone is sick, they need to stay home. We're all in this together. We all have to help avoid the spread of COVID. So the Employment Standards Act has recently been amended to include a new emergency leave provision for declared emergencies and infectious disease emergencies. We're going to talk about this more fully later on in this webinar, but just for purposes of this question, I will say that this leave cannot be imposed upon an employee by an employer in an effort to keep the workplace safe. An employer should certainly not send an employee home unless they have reasonable concerns that are in line with public health directives that the employee might cause a safety concern to others in the office. And then on a final note, please keep in mind that an employer's obligation to provide a safe workplace may extend to a home office as well. So it's not just the office environment where the employer is located. So that's the first question. The second one we're going to touch on is the following. I'm concerned my employer is not providing a healthy workplace. Can I refuse to go into work? So we've just talked about an employer's obligations to provide a safe workplace under the Occupational Health and Safety Act. That act also allows employees to refuse unsafe work, and so long as this work refusal is reasonable. And if it's not, then there might be discipline. So if an employee has a concern about work safety or the safety of working conditions, the first thing they should really do is speak to their employer, their supervisor, their manager, someone else in charge, or even someone in their health and safety department if there is one at their workplace. They either have been working from home or can continue doing so. They could always ask their employer if that's something they can keep doing. And you know, if they're just as productive at home, why not? This will also help the employer with physical distancing requirements. Now, for those employees who can't feasibly work from home or who have concerns about returning to work, should certainly ask their employer about what safety precautions they've put in place if they haven't already been advised, as well as whether the employees themselves are required to bring in any safety equipment. It's certainly going to be harder for an employee to take the position that their workplace is unsafe without first asking their employer what they've done on their end to make the workplace safe. And then if after an employee has raised these concerns, they still reasonably believe that it's not a safe workplace, the Occupational Health and Safety Act will allow them to refuse unsafe work. In order to do that, the employee has to promptly report the circumstances of the refusal to their employer, ideally in writing, and then that employer will need to investigate. If the employer determines that no, even after the investigation, we still think that our workplace is safe, the employer either has to return to work or they have to promptly make a complaint with the Ministry of Labor. If they make such a complaint, the ministry will conduct its own investigation and issue a finding as to whether the refusal was valid or not. The main thing to keep in mind for employees is that you certainly don't want to be seen to be abandoning your employment or resigning. You should keep written records of what you've done in terms of speaking to your employer, possibly filing a complaint with the Ministry of Labor, making it clear that the only reason you're refusing to work is because of safety concerns or safety issues, but that you do in fact want to return to work once it's safe to do so. However, if you're an employee refusing to work and there are no safety concerns or the ministry has already decided this workplace is safe and you're still refusing to work, this will definitely be seen as insubordination and possibly as a resignation from your employment. So there has been many work refusals around Ontario and the other provinces in Canada, but virtually none of them have been deemed to be a valid work refusal by the relevant ministry. According to my research, there's only been one case that was upheld in Ontario out of almost 300 work refusals. So just keep that in mind that, you know, the standard is reasonableness. It doesn't have to be perfect, and most work refusals are not valid. It doesn't mean you shouldn't refuse to work if you really do feel unsafe, but if it's mostly just a general fear of contracting COVID-19 or you're just anxious about it, that's not good enough. This is similarly true with the fear of traveling to and from work using public transportation. the fear in and of itself is not enough to trigger a valid work refusal under the Occupational Health and Safety Act. On the flip side, though, employers should also be mindful of the reprisal provisions in that legislation regarding those employees who have raised safety concerns, that they don't treat them any differently or possibly terminate them or do anything else that's negative in terms of their employment because they have raised those concerns. So overall, if an employer asks an employee to return to work, and so long as the employer has taken reasonable, necessary precautions to keep the workplace and its employees safe, and the employer is permitted to be open, the employee will be required to return to work. On a side note, this is of course subject to an employee's rights to the statutorily protected leave we'll discuss a little further along, and the employer's duty to accommodate its employees to the point of undue hardship. All right.
All right. Well, thank you, Karine, for taking us through the workplace health and safety issues. I know that's really on top of everybody's minds right now. One issue that we've been seeing, sort of coming up as we've been faced with the pandemic and the lockdown is, of course, childcare responsibilities. Of course, schools and daycares shut down in March of this year in Ontario. And ever since then, parents have been trying to basically figure out how to make it work. And employees who are expecting to have children in the near future are also wondering how they're going to make it work. So we've got a couple of our most frequently asked questions on this subject. So one of the big questions that we've been seeing a lot, especially on our employment law helpline, is okay, I understand, I think I get it, I think I understand how things would go if I had kids at home, but that's not my situation. I'm about to have my first child, or I'm about to have a child, and I was hoping to go on parental leave, let's say in September. And I was really banking on having, the requisite number of insurable hours of work before then so that I could get EI benefits. But now, because of COVID-19, I don't have those hours, and I'm really worried that I'm no longer going to be eligible for EI benefits when I have to go on leave. So what are my options? So this question raises a couple of areas of issues. First of all, just to recap what you need to be eligible for EI maternity and parental leave under the Act is 600 hours of what the Act calls insurable earnings or insurable employment in the last, 52 weeks, or since the date of your last claim, whichever period is shorter. And 600 hours basically translates to about 20 weeks of work at 30 hours a week. And so, if you don't have that number of hours already banked by the time you have to go on your leave, what do you do? The first thing that I'd encourage people in this situation to look at is possible remedies under the Human Rights Code. It's not the first thing that comes to mind, but if you're an employee and you're about to go on a maternity or parental leave, you were looking forward to it in let's say August or September or what have you, and your hours have been cut, the first thing you should do is take a strong look at, were you selected to have your hours cut because you were going on a leave or because you were pregnant? Did that factor at all into your employer's decision, or have you been grouped with other employees for similar cuts, and all of those employees appear to be people who are facing new parenthood? If any of that's the case, you might have possible recourse under the Ontario Human Rights Code. The Human Rights Code, of course, prohibits discrimination against an employee on the basis of sex, which includes pregnancy, and also family status. So if you're not the birth parent, but you are looking forward to taking a parental leave, and your employer's decision to cut your hours factored that in, then even though you're not the pregnant parent, you may still be entitled to recourse under the code. So And if there is that sort of situation in place where the decision has been discriminatory, then you really should speak to an employment lawyer, because that lawyer may help you to claim, in addition to damages for the discrimination, damages in lieu of what you would have been able to claim had you been EI eligible for your parental leave. So it's really important to canvass that subject. If it's a situation where you've canvassed the possibility of discrimination and that's not the case, but you're still worried about not having accumulated your requisite hours, there is the Canada Emergency Response Benefit, at least for the short term, and I think we've all heard about it in the news. There are certain requirements, such as, if you've lost your job or lost your hours because of COVID, you've earned at least $5,000 of employment income in the last 12 months or in 2019, and you're not making more than $1,000 in a 4-week period or in a 14-day period for the initial benefit period, then that's a benefit that may be used in the short term. In terms of the greater scheme of things and your period of leave that extends beyond the CERB period, we know that the federal government is aware of this issue. In fact, I think it was just a few weeks ago that the CBC published an article where they had raised this issue with the federal Minister of Labor, Carla Qualtrough, and I think what she said at that point was, we're aware of it. We know it's a gap in the EI program that is going to unfortunately persist after CERB is done, but we're working on a fix. It just is taking some time given the complexity of the EI administration program. So we know that there is a legislative fix hopefully coming down the line. But in the meantime, if there is, again, any instance of potential discrimination based on your status as a pregnant employee or an employee about to have a new baby, that's really something that should be investigated, and you may want to speak with counsel about your rights. Another question we've been seeing a lot of is, for workers whose workplaces are opening back up, and they're being asked to come back into the office, but schools haven't opened yet, daycares haven't opened yet. Can I be terminated if I don't have access to childcare? So basically, if I can't physically go into work because I don't have any school or daycare available to look after my child, what can my employer do to me? So first of all, I'm going to raise the Human Rights Code again. This could be a failure on your employer's part to meet their duty to accommodate employees. Again, employees have a right to be accommodated on the basis of pregnancy and or family status needs to the point of undue hardship. And so what does this mean? If you're an employer, you're probably wondering, okay, I get that I have this duty, but what does that mean for me? Well, it depends on the employer and the employment situation. If, let's say, you're an office employer and there's a possibility of issuing a work from home accommodation, then that will probably be one of the appropriate accommodations that you will need to make for the employee. It's important to note that if an employer has had a work from home arrangement throughout the pandemic lockdown period, and then now they're opening up and they're asking employees to come back into the office, it will be quite hard for an employer to argue that they can't make a work from home accommodation for an employee with childcare needs if that employee was already working from home during the lockdown period regardless. So, actions and actions that the employer took during the lockdown period will be relevant when it comes to judging, well, what's undue hardship and what does that mean for you? A lot of employers have had to adjust to providing work from home facilities in ways that they never thought they could. But now that it's shown to be possible for a wide variety of employers, again, it'll be hard to establish that it's undue hardship to continue doing so. In another kind of environment, let's say you're a food service employer or a grocery store employer, some of the accommodations you might have to consider, because obviously in those jobs it's hard to issue a work from home accommodation sometimes. Some of the accommodations you might have to consider are rearranging shift schedules, offering alternate schedules or work expectations or targets so that an employee can meet their childcare needs. So just because an employer is not an office employer, it does not mean, again, that they're exempt from this duty to accommodate. And then finally, you know, if, let's say, all avenues of accommodation have been considered and nothing is possible, as Karine mentioned earlier, there is the amendment to the Employment Standards Act that provides for, among other things, a job protected leave if an employee is providing care or support to an individual, so a member of their family, because of a matter related to COVID-19, including but not limited to school and daycare closures. So when we come to the last part of this question that asks, can I be terminated if I don't have access to childcare? Well, even if you've canvassed accommodations and they're just not possible, the employee is still entitled to this job protected leave to meet childcare obligations. And if an employer tries to terminate or otherwise discipline that employee for either seeking the accommodations or seeking this leave, they could be subject to penalties under the Human Rights Code and Employment Standards Act for unlawful reprisal. In all situations, we always recommend that you speak with an employment lawyer, either if you're an employee who is being faced with a return to work demand and isn't sure how to respond, or if you're an employer wondering, how can I get my workforce back to work while you know, being compliant with my requisite obligations, we'd be happy to help you on both sides of the table.
All right, so now our last topic for today is role changes due to COVID-19. First question we're going to talk about is, I was laid off and now I'm being recalled, and I'm asked to work different hours and or my responsibilities have changed. Is this allowed? Now, this is one of those questions that is extensively fact-specific. A lot of our work and employment law is fact-specific, but this is one that it's almost hard to give an answer here today. For this reason, if you are subject to such a change as an employee, or if you're an employer hoping to make these changes to your workplace, of course here, we at Nelligan Law would be happy to discuss your situation with you. But to provide some kind of guidance today, the main themes that I think would need to be considered with changing one's hours or responsibilities are abandonment or resignation, constructive dismissal, breach of contract, and the need to accommodate. As Malini had said, we have a newly created infectious disease emergency leave regulation. This was created under the Employment Standards Act. This grants significantly more flexibility to employers needing to temporarily reorganize their workplaces because of COVID-19. So one of the most significant changes are that employers are now able to reduce an employee's hours and wages for reasons related to COVID-19. This is without triggering the employee's termination entitlements or triggering a constructive dismissal. That said, the layoffs, the reduction in the hours or wages have to be temporary in nature. They only apply to non-unionized employees, and they're only going to be permitted from March 1st, 2020 until 6 weeks after the end of the declared state of emergency in Ontario. It's important to note that these amendments are within the realm of the statute, so the Employment Standards Act. Arguably, they don't oust an employee's common law rights. So some employees might still be able to claim that the changes to their hours or responsibilities constitute either a breach of contract, constructive dismissal, all of those things at common law, and give rise to common law entitlements. So the main question here is, can the employee refuse these changes? And honestly, depending on the circumstances, they might not be able to, and they might be deemed to have resigned if they do. And then on the flip side, even if you wanted to say, no, this is a constructive dismissal situation, the change is too broad, and we're speaking at common law here, well, the employee also has a duty to mitigate their damages. Do they have to return to the workplace to mitigate, even if it's working reduced hours? The other thing I find interesting is the new regulation only talks about a reduction of hours. It doesn't talk about an employer that might try to increase your hours or increase your workload. If they can only have half their staff coming into work, for example, they might try to put all of the work, maybe double the work of every employee who's coming in to make up the difference. So is that going to be a problem? Is that something that has to be accepted? So again, the question becomes, is this a fundamental change? Could it be considered a breach of contract? Is it a constructive dismissal? This is such a very fact-specific situation that other than advising you of the potential themes and potential pitfalls, we would really need to discuss with the individual what kind of work they do, what are their normal responsibilities, what are their changes, how long will they be going on for, and the like. Another consideration is what if for various reasons, speaking now about the potential of an increased workload, what if you can't do the additional work or work the additional hours for reasons related to family care, because of a disability, or other similar factors? So as Malini has explained, an employer does have an obligation under Ontario's Human Rights Code to accommodate its employees up to the point of undue hardship. So before an employer wants to force any of these changes on its employees, the employer needs to consider its accommodation requirements. And if it doesn't know that an employee needs an accommodation, but the employee brings it to their attention after the employer tries to change their hours and change their responsibilities, they can't just ignore those considerations. They do need to consider them. Otherwise, they might be subject to liability and damages on their end. So overall, a change in one's roles and responsibilities is one where the unique set of facts will dictate what is and is not permitted. So we do encourage you to reach out to us at Nelligan Law if you encounter any of these situations.
One other question we're seeing a lot of is, I as an employer have had to institute a pay cut, or I as an employee have received a pay cut because my employer says that they need to be more conservative with expenses due to COVID-19. But I don't know how long this pay cut's going to last for. And if it's permanent, well, that's not the compensation I agreed to when I took on the job. So what are my rights in that situation? So Karine mentioned two concepts that are, again, very relevant here, the concepts of breach of contract and constructive dismissal. If an employer reduces an employee's pay below what was agreed on in the employment agreement, let's say, they've agreed on an annual salary of $50,000, and then due to COVID-19, the employer has had to reduce that, let's say, to $45,000. Technically, that could be a breach of contract. However, depending on the magnitude of the change, which again is always fact specific, depending on the magnitude of the change, though, it might not rise to the level of a fundamental or substantial unilateral change, which is what we talk about when we talk about constructive dismissal. So what does that mean? Basically, if an employer makes a unilateral and fundamental change to an employee's terms of employment, that employer may be liable to the employee for the same kinds of severance entitlements that they would have had to pay that employee if they had terminated their employment. One really sort of extreme example of this, the one that I like to use, is if you have a VP of a company who's making $200,000 a year, and then the next day their boss comes to them and says, starting tomorrow, you're going to be you're going to be an intern and you're going to make $30,000 a year. Well, that employer hasn't black and white fired that person, but the concept of constructive dismissal would say they've basically done the equivalent of that because they have so radically changed this person's job from what they agreed to do. And then you see a lot of these kinds of changes that fall somewhere along the spectrum. So that would be kind of at one end of the spectrum, and then at the other end, let's say your employer tells you to start working at a different desk, a desk that's maybe 2 desks away from yours. Well, that is a unilateral change, but that's not really a fundamental change. Your conditions of employment, if all other things are remaining the same. And so you get a whole lot of spectrum of changes in between those two extremes. And when it comes to pay cuts, again, those are measured on a spectrum. Is your pay cut for 5 or 10%? Or is it, you know, the removal of a bonus entitlement? Or perhaps, you know, your employer has tried to reduce your pay by half. And actually, you'd be in a really difficult position if they tried to do that and double your hours, as Karine was saying. In that circumstance, you would really want to talk to one of us. But so when you're looking at reductions in pay, the first thing you want to look at before you even get into temporary or permanent is you want to look at the magnitude of the change. Some changes, if they're large enough in magnitude, may constitute a constructive dismissal. Alternatively, other changes like the removal of a minor bonus entitlement or a 5% cut or something may be a breach of contract, but maybe not a constructive dismissal. And, you know, if you try and end the relationship with the employer and claim severance, you might have a hard time doing that. You might really just be left with a claim for the difference in the salary, and your duty to mitigate would require you to continue working for that same employer regardless. And then you would have to decide if that claim makes sense for you. Then, of course, so you're looking at the magnitude first, and then, of course, you're looking at the time range of the cut. So if you're an employee who's had, let's say, a 5% wage reduction for 1 month, you know, the difference between what you got and what your contract entitles you to may not be a constructive dismissal, and depending on your circumstances, may not be worth claiming for. But conversely, if your employer tries to make that permanent, and it adds up over the months and years, even when COVID is no longer a factor, then, you know, the situation might be viewed differently. One factor that is going to be relevant is, you know, has the employer tried to tailor the measure to the specific needs that they were under because of the pandemic, or have they just viewed it as, you know, perhaps the impetus for a cost-saving opportunity and tried to implement a permanent reduction right off the bat? Those might all be factors that a court might find very relevant. One of the topics that I think has been making the rounds in terms of discussion on this subject lately, it actually stems, I think, from an article I saw, and a lot of people were sharing on social media about, you know, employers talking about, well, if my workforce is going to be remote, can I tailor their salaries to the cost of living in their home city? So can I pay my employees in Whitehorse less than I pay my employees in Toronto because they're working from home and their cost of living is different? The answer to that, again, is it's really going to depend on the circumstances. If you're an employee and your employer tries to do this, it's definitely worth speaking with an employment lawyer about your options. Similarly, if you're an employer who read that article and you're wondering if that's possible, really recommend you speak with counsel in terms of canvassing your options and seeing where your risks might lie.
One final thing I just wanted to note for both questions 5 and 6, if you're a targeted employee, or if your employer is targeting a certain type of employee for a reduction in pay or a reduction or change to your hours and responsibilities, for example, only the women in the office are subject to this change, that's not okay. That would be discriminatory. It does have to be reasonable. It does have to be non-discriminatory. So if you do feel that you've been targeted, even with the new regulation and what might be permissible for employers, that would not be permissible in any circumstance.
Yeah, that's a really good point. Thank you for that. So these are, you know, as we said, some of the questions that have been really top of mind, what we're getting in the past couple months of having our helpline open, and definitely today as businesses are starting to look to reopen. But what might be the questions of the future? You know, we know what the return to work may or may not look like. We can provide some thoughts on that. What might the future of work look like post-pandemic and in the coming months? So these are some of the questions, you know, we think are going to probably come down the pipeline. A lot of them pertain to working from home. So, you know, when some people in the workplace can return to work, but others can't return to the physical workplace, whether because of childcare needs or what have you, how might that impact office dynamics? And how might that impact, you know, the opportunities that are provided to some employees versus others? So, Karine, what are your thoughts on that?
So I have returned to the office. I made the decision that I didn't want to work from home anymore, and I didn't have to. I don't have any childcare responsibilities or any other types of responsibilities, but some of my colleagues do, and they can't currently return to work. So one thing that came to our minds is, well, those that can't come back to work and those that might not have that face time with their supervisors or their managers that are in the office, are they going to be treated differently, maybe not as well, because they haven't been able to come back? Maybe they haven't been able to work as many hours, or maybe you just don't see them as often as you see someone else. So am I going to get more opportunities because I have returned to the office as compared to some of my colleagues who honestly just can't? Something that we're thinking might become an important topic in the future. And also, I've heard from a lot of my my clients, either I just want to work from home permanently now. I've been productive, and I don't want to do the commute. My commute is an hour each way, and I would really just rather stay working from home. On the flip side, I also hear from my employer clients, all of my employees want to continue working from home. I need some of them in the office. I certainly can't operate, or I can operate with them working remotely, but I prefer having them in the office because we used to have a lot of meetings, collaborate, things like that. Can I, or am I supposed to allow all of my employees to continue working from home? So these are some things that I've heard recently, and I think they're going to become more relevant as the next months come along, and we see how, you know, the impact of people returning or not returning will have on their employment opportunities and on life balance, and just on, you know, what we can see going forward.
Yeah, I know I've heard, especially from you know, friends in sectors such as tech, where some companies are actually embracing the shift to virtual work, and they're now saying that, you know, they're going to give up their office space, they're going to give up their office leases, and their full workforce is going to be remote going forward. And so some employees, I mean, there are always people who fall on either side of the fence on this one. Some employees say, hold on a minute, I'm sick of working from home. I don't want to work from home anymore. And I really want to come into the office. And, you know, what's going to happen to, I mean, it sounds silly to say, but it's not silly to think about. You know, there are all these ancillary perks that sometimes employers offer in recognition of the fact that they ask people to be in the office, such as, you know, cold brew taps, beer fridges. I'm trying to think of all these tech company things that I've heard of. And, you know, so companies also asking, well, you know, what on earth is the point of having a cappuccino machine in my office anymore? You know, one of my employees complained because there's no cappuccino machine, but why would I keep up that expense if I don't have people coming in physically? So we can see that, you know, these issues, they can trigger some definitely human rights concerns, discrimination concerns, depending on the differential treatment of employees who are staying at home to meet childcare obligations versus coming in when they don't have those obligations. But there's also these softer aspects of differential treatment that aren't as easily quantifiable. And, you know, how might that change the employment relationship moving forward? I do certainly think that after this, we might see employers introducing the concept of a temporary layoff clause much more often in their employment contracts up front to try and mitigate the risk of constructive dismissal if they might have to put employees on layoff in another lockdown period, goodness forbid. So things like that, I think, are going to be top of mind, and we've definitely got our finger on the pulse of these issues to come.
One other thing I wanted to add, based on what Malini was saying, that, you know, some employers have embraced working from home permanently. in some workplaces, I'm aware of some of my friends in different workplaces that have accepted maybe a lower salary in exchange for all these perks and benefits that they get at work. And now if they're working from home permanently, they're not going to have those perks and benefits, which led them to agree, or was an incentive for them to agree to maybe a lower salary. So now that those are gone, should they get an increased salary? Is it going to be bad enough that it's going to fall on the side of a constructive dismissal if everything is taken away other than their salary? So these are other things. Obviously, that's very fact specific, but certainly something that came to my mind when one of my friends told me that, you know, going forward, she's working from home and they're not going back to the office. And all I could think of is you're losing out on a lot, because the office environment actually created quite a lot of opportunities apart from the job itself. So something I think that will continue, questions that will continue to be asked when people don't return to the workplace.
And if you're an employer and you have questions along the same lines, you know, feel free to reach out to us. We're more than happy to help you.
So that's everything that we have for today. I want to say thank you to everyone who decided to join us. We know this is very top of mind. There's a lot of webinars going on right now. So thank you for joining Nelligan Law today. We hope that this session was helpful. If you're experiencing any of the issues that we discuss, the question that you're likely asking yourself is, what do I do now? So speak to your employer or employee. That should always be a first stop that you do. If you're still having trouble, consider getting legal support. If you're in a situation where it might result in legal action, it's always a good practice to keep notes of what you're going through, to get all the details, dates, specifics, just so to make sure that you don't forget those. So as we mentioned at the beginning of this webinar, these are very uncharted territories. As the phases evolve, we're not sure how the courts will respond to all of these issues coming up. We do see the legislation changing a bit with regulations, but other than that, we're not sure. We're all moving along with the changes together. But if you have any questions that weren't answered today during the webinar, please do send your questions to the website that you see on the screen, webinars@nelliganlaw.ca. We're not going to answer your questions individually, but we would be using those to guide perhaps another webinar, future blogs, or any other written material that might assist in answering those questions. We are continuously updating our information at our website, www.nelliganlaw.ca. We encourage you to check out the COVID-19 Resource Center on the site for more information. And as a final thought, in these unprecedented times, one thing is very certain, that all of us will have to adapt. So thank you very much for joining us today.
Thank you so much.
Thank you, Karine and Malini. So I'm going to end the webinar now. Thank you guys both for speaking, and thanks for all of our attendees for taking the time to join us as well.